If you're about to undertake an advocacy assessment as part of your course, or if you are preparing for a moot, this video will hopefully be of assistance. If you're about to undertake an advocacy assessment or a moot for the first time, then chances are you are feeling a bit nervous, particularly if you want to perform well and achieve a good grade, or defeat your opponent. Don't worry, nerves are completely normal at times like this, even for seasoned professionals. What is very true, however, is that the more preparation you do, the less nervous you will feel on the day. And remembering to use these 6 key tips will help you perform more competently and can save you from making some common mistakes.
Your Honour, my name...
Miss Hammond, could you please use the correct mode of address?
It is very important to use the correct mode of address. This hearing was before a district judge in a county court. For this type of hearing, the correct mode of address is sir for a male judge and ma'am for a female judge. Some judges will be very annoyed if you use the wrong mode of address.
My name is Miss Hammond and I appear on behalf of the claimant, Wallace Tickley.
If you are speaking first, always ask the judge whether they want a summary of the facts. Obviously, if your opponent has already given these, then there is no need. Also, out of respect, it's best practice to always ask the judge for permission to continue or proceed with your submissions at appropriate intervals, such as after you have answered a judge's question, for instance.
On the 5th of November, the claimant was returning from his lunch break at his place of work.
Miss Hammond, I've read all of this previously.
It is best practice to ask if the judge wants to hear a summary of the facts, rather than to assume that they do. This may save a lot of time.
Would you like a summary of the facts, ma'am?
I have read all of this previously.
Three, state the law precisely. Whether you are referring the judge to a case, a statute, or a statutory instrument, you must always be exact. With a case, this means when using a quotation from a judgment, ensure that you refer the judge to the exact page or paragraph on which it can be found. Likewise, with an act, always refer the judge to the exact section number, paragraph, and subsection as appropriate.
This is an application for summary judgment under the civil procedure rules for the claimant.
Which part of the rules are you referring to, Miss Hammond?
It is very important to lead the judge to the exact part of the law your arguments or submissions are based on.
This is an application for summary judgment under Part 24.2, subsection A, subsection 2 of the Civil Procedure Rules 1997.
Four, lead the judge numerically. When delivering your submissions, lead the judge through any points you have in a logical, numerical order. In most cases, this should be done by referring the judge to your skeleton argument.
The claimant's argument is that the dust levels in the warehouse environment were too high and that the defendant negligently failed to control these on the basis that they failed to take any reasonable precautions to ensure that the working environment was free of hazardous materials.
When delivering important submissions, leading the judge numerically is usually a good idea. This makes the judge's job easier, particularly when they are delivered at an appropriate speed, not too fast and not too slow.
The claimant's argument is that the dust levels in the warehouse environment were too high and that the defendant negligently failed to control these on the basis that, first of all, they failed to take any reasonable precautions to ensure that the working environment was free of hazardous materials. Secondly, they failed to ensure that the working environment was cleaned regularly or at all. And thirdly, they failed to ensure the availability of any appropriate cleaning items or equipment.
Keep your documents or bundle organised. This is important for many reasons, but in this context it can be very helpful in terms of responding to questions about the facts from the judge. There is no way of knowing what question a judge may have, but ensuring that you have the facts literally at your fingertips will mean that you have this area more or less covered.
Could I ask a couple of questions? The first one, what date was the examination carried out? And what is the date of the medical report?
Just wait a minute there. I just need to find that information.
Miss Hammond, the court is waiting.
I have it. The medical examination was undertaken on the 4th of December and the report is dated the 5th of December.
It is always a good idea to keep your papers well organised so that you can find key information when you need to. Using tabs is wise.
Could I ask a couple of questions? The first one, what date was the examination carried out? And what is the date of the medical report?
Yes, ma'am. The examination was undertaken on the 4th of December and the medical report is dated the 5th of December.
Six, direct the judge to the documents. When referring to specific evidence within your documents or bundle, always refer the judge to the exact places where the evidence can be found.
The reason we have for saying that the defendant cannot defend this claim are that the evidence is not very strong, the warehouse was very dusty, the defendants knew this, and there are many witnesses who support this version of events.
When directing the judge to the evidence within your papers, always direct them to specific documents containing the evidence you wish to rely on. Your aim, as an advocate, is to show the judge why your argument should win, so show them with accurate reference to the evidence.
Firstly, the warehouse cleaning rota shows that the warehouse had not been cleaned in 3 months prior to the incident. Secondly, the witness statement of Albert Winch contains an admission at paragraph 6, which shows that the defendants were aware of the problem with the dust, yet failed to act on it. Thirdly, there are multiple witnesses to the incident who all support the defendant's version of events.
I hope this has been helpful to you. In closing, I would like to invite you to approach any advocacy assessment or moot as if you are showing the judge a roadmap, or as if you are giving them directions in order for them to arrive at a specific destination. The destination in question is the decision that you want them to make. The clearer you make your instructions, by showing the judge the exact rules of law and exact pieces of evidence which you are making your submissions on, the higher the chance is the judge will arrive at this destination. Cheesy metaphors aside, I wish you the best of luck.